Well, firstly, thanks to Angus for remembering me when he came to put the list of speakers together. Now, I have to say, I did rather commit myself before I realised quite what the seminar was about, which may explain some of the stuff that's about to come. A little bit about the introduction of a foreign language here. That'll become clearer in a minute when I explain a little bit about, firstly, what UKLR is, because I think it's quite important to do some of that so you understand why I'm talking about what I'm talking about in the way that I am. Before I get on to that, I think Keith earlier on made the point that badgers don't get to bring cases. Well, neither do hedgehogs. Despite the title of Ronald Dworkin's last book before he unfortunately passed on. It struck me on the way down here. I'm not sure whether that's an Algerian hedgehog or a European hedgehog, which make considerable difference to its status in wildlife law at the moment. Because it's an Algerian hedgehog. It's an appendix. It's an Annex 4 protection, which is really strict. As a European one, it might have a few more problems. Now, a little bit about the structure. First of all, I'll give you a general idea of what UKLR is about, what our membership is made up of, and hence then why I'm going to talk about what I'm going to talk about. I'll give a general overview of UKLR's view of particularly the Law Commission's project, and specifically the interim review that's been published recently, which I think highlights perhaps some of the more pertinent issues, some of the issues that caused most response from consultees and so forth. And in particular, I'm going to look at these particular issues. When I get to the penalties slide, for some reason I've missed off the civil sanctions one, so I'll do that off the top of my head. I do know a bit about civil sanctions, so that should be okay. Firstly then, UKLR is a nationwide body. It stands for the United Kingdom Environmental Law Association. It got going in the tail end of the 1980s, so we've been around for a little while. Principally, we are made up of legal practitioners, mostly barristers and solicitors, and that covers both sort of claimant and defendant lawyers. So you can imagine we have some very polite but very robust exchanges of views at our meetings and so on. But our primary purposes are up there. That's taken from our Articles of Association. And that's what we seek to do. We are overtly not a political organisation, so we don't really get involved in lobbying. We don't try to influence the content of the law overtly, apart from anything else that would threaten our charitable status, so we don't do that. What we do, however, is to seek to get involved at the very earliest stages in consultation in order to try and ensure, through what I call our Aim 5 principles, again, the fifth aim of our Articles of Incorporation, and we try to encourage the passage of legislation which complies with those three requirements to the maximum possible extent. Principally because an awful lot of our membership, of course, is in the business of actually litigating on the basis of it. It makes for much better law for everybody concerned if these things are given due attention. And of course the reason we go for those is because ultimately if you've got those, you've probably got effective law, though I could bore you for a long time through my research interests, but the measurement of the effectiveness of legislation, which I'm rapidly reaching the conclusion is nigh impossible. I think you have to make sure you get it right in the first place and then hope it's going to be effective, but that's for another day. So moving on then to the sort of general view that UKLR has put forward. I should just point out that UKLR is split up into a number of working parties, so we'll have regional groups. We've got a group in Wales, which I'm one of the conveners of, despite the fact that I work in Birmingham. It's slightly odd, but I am from Wales originally, as you may have gathered by now. So we have regional groups up in the north, in Scotland, in Northern Ireland and so on. But we also have specialist working groups as well. So we have a waste working party, we have a litigation working party, we have a nature conservation working party, and it is to them that I owe a debt of gratitude for a lot of the material that's here today. And they're the ones that generally undertake our consultation responses, and certainly they did in this case. Though of course in Wales we have to take a sort of a view of just about everything, so I have to keep an eye on just about everything to do with the environment. Particularly, and I'll have more to say about this later on, in light of devolution, which is having a profound effect on the way these things are implemented. And as you'll see, I think that's an important issue underpinning these reforms. You could pass a single piece of legislation, if you want to, the chances of it actually being implemented in the same way in the devolved regions, that's another issue. But I'll return to that at the end. Some of the things that, well, I've put perceived threats here. I mean, I suppose that's unnecessarily pessimistic. Some of them could be opportunities as well. But the ones that we are concerned about in the UK are certainly the better regulation reforms and the red tape initiative that the government's been undertaking for a little while. Some of the language associated with that is it saying too much to say sort of anti-environmental protection? So that's certainly our view, and it's certainly the view of the Nature Conservation Working Group. Some of that language may have infected the Law Commission's project, with great respect to Keith. Unfortunately, I'm standing up here speaking for UK rather than for myself, so I will hide behind that slightly. But phrases to do with decreasing burdens and not interfering with economic growth and so on. One or two of our more enthusiastic members find that language slightly worrying. And certainly a recent press release from the Department of Business, Innovation and Science was lauding the fact that 800 pieces of regulation have already gone, where they targeted another 3,000 pieces of regulation which they see as unnecessary. In this bonfire of the regulations, just hoping nobody gets burned too seriously, that's all I can say. But, so that's one of the things we are somewhat concerned about. My own personal interests, perhaps more in wildlife law, has been waste law for some time. And we are quite concerned I have some association with our waste group as well. And we received a letter from Dan Rogerson, who I think is the Parliamentary Under Secretary for Water, Forestry and something else, to the effect that the government's sort of initiatives on policy in relation to waste are basically being brought to an end. They're not going to invest in policy innovation in waste to any great extent in the future, on the grounds that the industry is very largely regulating itself. I hope that's not a precedent for what we're talking about today. I sincerely hope not. So that's why we consider that perhaps to be a bit of a threat rather than an opportunity. Devolution, I've already mentioned, I'll come back to that again at the end. Are we going to stay in the EU? Maybe slightly longer term threat, although I'm a member of the National Council of UK as well. We have 4 meetings a year in London, and several of the members of that committee are quite close to government. And they did surprise us somewhat as to the sort of extent of preparation, not only in Westminster and Cardiff, Edinburgh, particularly Edinburgh of course, and in Belfast, sort of in preparation for this contingency should we leave the EU. A lot of sort of, which you might call horizon scanning, has gone on already, and that's not just limited to the UK, that's also the case in the European Commission, which has also undertaken a number of sort of contingency reports on what's the EU going to do if Britain secedes. I don't know what the answer to that is yet. And then finally, of course, there's, in terms of the piece of legislation that we hope is going to be forthcoming in draft form on wildlife reform, there's the question, of course, of whether we'll get sufficient parliamentary time in the existing parliament, and then what happens if we get a new government and so on. One of my students yesterday pointed out to me, although I confess I haven't had time to check on the accuracy of their analysis, but they said that there's a greater chance of a private member's bill on circus regulation becoming law than this one. That was their analysis. I didn't have time to check it out on the train, but again, I hope not. So, some particular issues that we have brought forward. Now, we understand very well the logistics of the task that Keith undertook here. This is a massive undertaking. And we understand perfectly well why dealing with habitats as well as wildlife law reform would have been an even more gargantuan task. Nonetheless, we do, and these are extracts from minutes of our own working groups which summarise our concerns about this. There is an issue, that question, about divorcing wildlife protection from habitat protection. Functionally, the two can't really be separated, particularly in terms of biodiversity. You can't protect species without the habitats upon which they depend. So, it is against that background, everything else I'm going to say should be considered. So let's come to some specific issues, and a lot of these will relate to what my predecessor Mark talked about in terms of penalties. Obviously, as lawyers, you'd expect us to be interested in the particularly legal issues. So the next bit of it is going to be a bit more legalistic, but hopefully will be on point. The first question is this question of criminality and the criminalisation of wildlife crime. And there is a mismatch at the moment between the language used in the European Court, where they tend to talk about deliberate as the language of the directive, so that's understandable, and the way in which we've chosen to implement that into British law. We've chosen to use well-tested and well-understood, perhaps not well-understood, but certainly well-tested concepts like intention, which perhaps is fairly well-understood, and recklessness, which, frankly, any lawyer that tells you they understand recklessness is either a liar or not a lawyer. I'm not sure which it is. But we have tended to do that in the past. In UK, I'll have to say we do welcome the interim statement's intention to bring in the concept of deliberate as a freestanding element of European law. We don't think there's anything to be scared of in that. And those of us who are environmental lawyers are in any case familiar with this kind of thing, because we've been wrestling with the European Court's definition of discard in waste law for many, many years. This holds no fear, frankly, by comparison. I mean, that's even less understandable than this. So we are, broadly speaking, in favour of that, and we think it will, to some extent, broaden the scope of the offence, particularly the defence of intention. If deliberate is used instead of intention, it is our view as lawyers, and I'm deferring to barristers who do this on a daily basis now, their view is that deliberate will bring the sort of criminalisation of certain wildlife crimes down here a little bit. So that, in other words, you have to be slightly less culpable in order to be found liable, and we welcome that on the whole. Of course, there is the risk that you then push, you bring it down here as far as intention is concerned, but take it up a little bit where recklessness is concerned. Though, as I understand it, or I think Keith will correct me if I'm wrong, for domestic species, the intentional reckless distinction is to be retained anyway. So for European protected species, am I right in my interpretation?
Probably.
Yeah. Right. Well, that's good enough for me.
Well, because the option is just to go to bird, which is essentially deliberate across all species, which is bird or EU,
well,
which leaves two species.
Yeah. Well, we're all for simplification of them, so we welcome that too. So that, is something that we do welcome. The middle way, as they describe it. Those of you who are practicing Buddhists will immediately go for that. Or those of you who practicing Aristotelians for that. Vicarious criminal liability has been brought up. This I have particular interest in, because I'm also a sort of tort lawyer as well. Of course, vicarious liability is a well-used and well-tested creature in the civil law. But vicarious criminal liability is very rare, of course, for very good reasons, because you end up criminalising somebody in the absence of culpability. And without getting into jurisprudence and electoral legal theory here, that is pretty badly contrary to most of the precepts of natural justice, and obviously is to be avoided on the whole. Except in exceptional circumstances, perhaps, and there are occasions, certainly, of vicarious liability, particularly in America, certainly in certain contexts. If stepping outside wildlife law for a moment, if you commit a rape during the course of which somebody dies, you're vicariously liable for their murder, whether you intended to kill them or not. So it does exist in certain instances in the criminal law, but it is very rare. I think politically, the Law Commission is very right here, introducing full-blown vicarious criminal liability for these offences is in danger, I think, of bringing the law into disrepute. The fine line has to be drawn here. Now, having said that, they have gone in the interim statement for, am I doing the time? Yeah. For knowingly permitting, which is a sort of halfway house. We have quite, and certainly my own background is far less in wildlife law, but I've done a lot of work on environmental protection in the context of industrial pollution, the control of industrial waste and so on, and water offences as well. And this form of words has been with us for quite a long time. And if you look, this is an extract here from, not from wildlife law, but from the environmental permitting regs of 2010. And you can see there that the words knowingly permit appear in a number of places. This is in relation to causing a water discharge activity, in other words, polluting controlled waters is essentially what that means. And you can see there it's a two-pronged alternative approach where you can either charge someone with causing or knowingly permitting. Now this has a long history, it goes back to, well, it goes back to 1959 actually, but most of the cases were brought under Section 81 of the Water Resources Act, which is one of the more successful pieces of criminal legislation protecting water, but almost exclusively, for obvious reasons, or reasons that will become obvious, the regulator went for the cause rather than knowingly permit. The reason for that is that because of a rather odd case called the Empress Car Company case, and some of the things that preceded it, a case called Alpha Cell in the 1970s, you can do someone for causing a water discharge activity even if they didn't know it had happened. In other words, there's no need for knowledge. Now, of course, the criminal offence associated with that was quite a serious one, certainly by comparison to wildlife crime. So you could, at the time, you could get £20,000 fine, even in the magistrate's court, and up to 6 months imprisonment. Sorry, 3 months imprisonment then. And that could be done on the basis of no knowledge at all. Well, of course, culpability, criminal culpability without knowledge is strict liability. So there is a precedent for what's been put forward here, but the fact that they've gone for the knowingly bit, yeah, go on.
Can I give you a little bit of drafting history to the interim statement?
Go on in.
We mean cause and knowingly permit. There was an annoying argument that happened, not annoying, there was an argument that happens that said that arguably you don't need the cause part at one level of drafting, so if you cause something then you may be liable anyway. Consequently, you should mention it, but what the Law Commission meant, and I think that it might have helped, would be that we meant cause and knowingly permit.
Right, okay. Well, in that case, I can move on. The point I was going to make is, though, really that the problem with knowingly permit, if it does require a level of knowledge, is this one, where people are going to ignore what's going on. There's going to be an encouragement to people who have people working for them, for instance, who may commit wildlife crime, to know as little about what they're doing as possible, in order to say, well, yeah, okay, how can I have knowingly permitted it if I knew nothing about the law? I suspect, though, that waste law will come to the aid of wildlife law here, because in waste law there's an offence called knowingly cause, but if you look at the case law, not much knowledge is required at all, and it is also possible to interpret that as requiring constructive or constructive knowledge. In other words, you either knew or ought reasonably to have known as a reasonable estate manager, wherever it is you are. So I think there may be some teeth in this, but a lot will depend on the interpretation that the courts put on. A good bit in the interim statement about licensing and conditions. Again, very familiar with this in control of pollution from industry, where conditions have been used for a long time. Huge, long list of offences to do with failing to observe conditions on an environmental permit, for instance. And we very much welcome this. It's got long usage. I think probably the conclusion is that it's been pretty successful in terms of environmental pollution control for industry. There are some downsides. Again, depending on the penalty, you can end up criminalising someone even when no environmental damage is concerned. And we've already shared something from Mark and from Keith about the sort of victimless crime. Well, this is kind of the opposite, if you like. This is where companies that have been undertaking a reasonably good industrial activity have nevertheless allowed some pollution to leave their premises, or they've broken a condition, either a tiny amount has gone, or in fact nothing has escaped at all. And then, of course, they're prosecuted. And of course, there's lots of stuff in the press. Prosecuting these people who have done anything wrong, no damage to the environment. Most of those press releases tend not to go as far as what the penalty was, because generally speaking, although it is possible to be liable, certainly criminally liable as well, and you do get that recorded and your name did shade on the Environment Agency's website or wherever it is, the fact is when it comes to imposing a penalty, magistrates and indeed Crown Court judges will take into account the fact that no actual damage has been done. And then if you look at the Environment Agency's prosecution guidelines, GPS and the rest of it, it is possible to sort of mitigate that criminalisation through the penalty, though it is the case that you can end up criminalising someone even where no damage to the environment is concerned. And I think that needs to be borne in mind if we do introduce offences relating to licence conditions. And of course there is, to some extent, an additional regulatory burden involved in the administration of that. But we think it does add coherence, so that's why we're in favour of it. Penalties, we recommend in parity with other crimes. This has somewhat been overtaken by events, so I'm not going to dwell on this. Keith mentioned earlier on that the limits, the upper limit in magistrates' courts is to be removed. That is as a result of the Legal Aid Sentencing and something or other Act, I can't remember the last part, which was passed in 2012. Section 85 to 87 of that, I think, removes the upper cap on penalties in the magistrates' court, and I think that will help enormously with perhaps building out a level of deterrence. Again, the penalties thing in wildlife crime, I'm relatively optimistic about that, I have to say. We've gone through this again in industrial pollution crime. We met some years ago where penalties were tiny, it was completely different depending on where you're in the country. If you were in the southeast, you could look forward to a £10,000 fine. In the southwest, £300 would be excessive sort of thing. A lot of that has been regularised across the country thanks to sentencing guidelines and things like that. And of course a raising of the ceiling, because for industrial pollution, prior to the most recent legislation, we were at £20,000 even then, which is much higher than the normal maximum for wildlife crime, which is £5,000. But as I say, that particular issue I think has gone away in many cases. And then finally, how am I doing? Finally, this question of devolution. Now, you will have to stop me going on at great length about this, because I know a great deal about these three. If you really want me to go through them, I will. No. No, I can give you it. But a serious point here, I mean, the amount of disparity or diversity now between the regions of the United Kingdom is really quite profound. In some areas like waste law, for instance, there are considerable differences in the way that waste is managed and the law applying to the handling of and so on in different parts of the country. In Wales in particular, and I make no apologies for speaking about this for two reasons. Firstly, because I'm very interested in it, that's why I'm going tonight to my parents' place. But secondly, because I've been studying these since their inception. We have something now called the Future Generations Bill. Now, very much depends on the text of that piece of legislation. It's going to be placed, we are told, before the Welsh Assembly in July of this year. And it will basically create a duty on public bodies to incorporate sustainable development as their central operating principle, the law says. Now, that formulation of sustainable development, as I understand it, is going to be fairly closely based on the classic sort of Brundtland definition. But it does require that a balance is struck between the three, or in this case, four pillars of sustainable development: social, environmental, economic, and they've also added cultural as well, obviously because of the Welsh language and so on. There are some things about that do worry me. The first thing is that the Future Generations Bill started life as the Sustainable Development Bill, and it was in that ministry in the Welsh Assembly then, which had the word environment in its title. Unfortunately, I think it's unfortunate, last year a sort of ministerial reshuffle and restructuring of the Welsh Government took place, and there is no longer a government department there with the word environment in its title, nor is there one with the word sustainable development in its title either. This has passed into the hands of a ministry for, what's it called now, the alleviation of poverty. That does worry us somewhat, and we've been trying to find out from the Welsh Government whether this Future Generations Bill is going to major on economic matters at the expense of environmental ones. If that's the case, this is kind of the overarching piece of legislation which the other two, in effect, will have to defer to. So if that balance is wrong out here, that's going to have serious implications for the implementation of any future wildlife protection, in my view. And it's not just my view, there's quite a few of us on the working group in Wales, and we all have some considerable concerns about this. And we have so far failed to get any really very straight answers out of the Welsh, the reference group responsible for it. But on the other hand, of course, it could be an extremely good thing, and you could end up with a much stronger protection for wildlife in Wales than perhaps you'll get in England. And of course the same will apply to the other devolved areas as well. And in terms of wildlife and its dependence on habitat, the fact that separate planning arrangements are being put in place in these regions is also going to have a profound effect. I'd like to tell you what that effect is. The fact is I don't know. I haven't got a crystal ball. I wish I did. But you are likely to end up, I suspect, with a situation like this where our hen harrier here is going to have to make a decision as to which part of the United Kingdom might it be best to live in. But hopefully, certain more sanity will prevail, given that wildlife doesn't respect geopolitical boundaries. Hopefully, some slightly more joined up thinking will take place. Okay, that's it. Thank you for your attention.
Any questions for Haydn? Yep.
Sorry, Trace Warren, I remember my question. You were talking about, in relation to the penalties, Haydn, I just wondered if you have any thoughts or UK's views in relation to the sentencing council's guidelines where wildlife crime has been obviously left out of those guidelines, and they try to rationalise that by saying it was too complicated.
Yeah, we were not at all in favour of that, no. There was both the litigation group and the Nature Conservancy working group were apoplectic about it. And put a very strong letter, which I haven't got a copy of here. And the litigation group basically said it was, I think they went so far as to use the word disreputable. So, no, we're not very keen on it at all. I mean, it should be there. It's just as important an area of environmental protection as, I don't know, industrial emissions. I mean, I understand the complexity, but I mean, you've got to start somewhere. You can't just say, oh, it's too complex, so I'm not going to do it. You've got to make an effort. So, no, I agree with you. I mean, in terms of the sort of penalties thing, of course, it's all very well putting penalties in, and I've perhaps taken a lot of, what's the word, encouragement from what's happening with industrial. Because I'm fully aware of the fact that you're dealing with a completely different issue here. I mean, factories stay where they are. It's very easy to find out what's coming out of them. They can't go away. They can't hide the tracks of what they've done very well. And I'm not underplaying the difficulty of applying the same principles to people who, almost by definition, go out dead of night, as in recently in Rossshire in Scotland, where 12 red kites were poisoned and flying buzzards. So we're alive to the difficulties of it, but I think we do have some history, some successful history in using higher penalties to create a better deterrent effect. And I think I'm quite encouraged by it. I mean, the only thing I didn't say on here, because I was kind of running out of time, was this whole question of civil sanctions, which perhaps we can pick up in the discussion afterwards. There is some quite important stuff to say about that, which I won't go into now because we'll be here for ages. But certainly, we have been very concerned, and the chairman of our litigation group, who's now in fact the chairman of UK as a whole, wrote to Michael Fallon at BIS, expressing our great disquiet about the suggestion that civil sanctions in the future are to be restricted only to companies with 250 employees or more. That seems to us to completely defeat the original purpose. Yeah.
Just in the last few weeks, there's been incidents of Proceeds of Crime Act being used for wildlife offences, act offences. Yeah. And I think that does really open up.
Yeah, I agree with you. That's another area where we're very keen as well. And we've explicitly stated that we think that is a way forward. And again, that's been used very successfully in the context of waste law, organised crime, and so on.
There's always a discussion whether they could be used in many wildlife crimes because of the so many nature of offences. It's been shown now without that.
Well, and particularly when Mark earlier on showed our friend leaving court with a smile on his face, having been smuggling ivory, is a classic case.
Yeah.